Buenos Aires, Argentina, is one of the most beautiful cities in the world. It's often called the Paris of South America. But for hundreds of years, Buenos Aires has had a dirty little secret. This river is the Riachuelo, and it forms the boundary between the city of Buenos Aires on this side and the province of Buenos Aires over there. The Matanza-Riachuelo basin is 80 kilometers long, and it's home to nearly 5 million people. For more than 200 years, it has been horribly polluted, carrying the runoff from tanneries, oil refineries, chemical industries, shanty towns, and farmlands. As the new millennium began, its surface was matted with debris, and the river was littered with 53 abandoned ships, not to mention old cars, bathtubs, dead horses, and other stuff you don't want to know about. Then, in 2004, a little band of residents from an impoverished riverside neighborhood brought a lawsuit against the city, the province, the national government, 14 upstream municipalities, and 44 private companies, alleging that these organizations had damaged their health and infringed their right to a healthy environment. And the Supreme Court of Argentina agreed to hear what's become known as the Mendoza Case. Their lawyer was Daniel Sallaberry, who was frustrated that Argentina's admirable environmental rights statutes had never had a solid, real-world test. On July 8, 2008, after 4 years of hearings, the Supreme Court handed down a landmark decision not just for Argentina, but for the world. In a judgment that one observer called sweeping and poetic, the court ruled that government and industry had indeed infringed the residents' right to a healthy environment and were obliged to repair the damage. Furthermore, the work would be supervised by a citizens group and by a judge. But when the court found that although the companies involved had indeed infringed the plaintiffs' right to a healthy environment, the plaintiffs should nevertheless pay their own whopping legal costs. That finding will be appealed to the Inter-American Commission on Human Rights. I want to go back and ask you some of the questions about where the case came from and about your clients. Well, you had 17 clients?
Yes, 70 clients.
And how did that come about?
Its implications. It has two implications, a legal one and a sociological or a social one. The legal implication is related to the incorporation into Latin American law. In this case, Argentine law, of third and fourth generation rights, which include environmental rights, the rights of nature. This legal regime was incorporated into the national constitution in 1994 in 3 articles. Article 41 incorporates these rights by establishing that all inhabitants have the right to enjoy a healthy environment.
And that's in the Constitution. Yes. Yeah. Good.
Article 41, which guarantees citizens' right to enjoy a healthy, stable environment, able to support human development and productive activities that satisfy current needs and the needs of future generations, at the same time incorporates the obligation to conserve this environment. It incorporates the rights to bring class actions, and it establishes in subsequent provisions the legal procedures for defending those rights.
Yeah, no, so it's what comes after the decision as well as the decision. Yeah?
Subsequently, laws were passed, like the General Law of the Environment, that provides how these rights will be implemented. This was in 1994. Then, from 1994 to 2004, when we brought the lawsuit, 10 years passed in which these laws were never applied. The big problem in a country like Argentina is the effectiveness of law. The law can be declared in the Constitution, but if it is not properly practiced, it is just dead letters. Then, in 2000, after 6 years had passed since these rights were established, the newspaper La Nación published an editorial noting that in the Riachuelo River, 500,000 barrels, each containing 200 liters of toxic waste, were dumped in the river on a daily basis. And that the Secretary for the Environment, the agency charged with enforcing the law, monitoring industrial pollution, and protecting natural resources, was well aware of this and permitted companies to dump the toxic effluent. At the same time, the newspapers began reporting on victims who were affected by the pollution. There were people who had lead in their blood as a result of being poisoned, like the case of Doc Sud, the case of Beatriz Mendoza, and another group of families who formed the basis of the suit. There were 17 families, a total of 120 individuals, in which evidently they suffered health effects. And the question arose, how many cases could I bring? And the answer was,
let me put a little, go to the side for a minute. I have read somewhere that Beatriz Mendoza had cut herself and couldn't feel it because of the contamination in her body. Is that true?
That's one of the pathologies that the pollution caused in this charming case. In Doc Sud, there are 18 gases. These components mixed together affect health in different ways. In Beatriz Mendoza's case, the pathologies were loss of sensation, general malaise, and problems with concentration. In the case of Villa Inflamable, the children suffer from lead poisoning. The levels of lead in their blood are significantly higher than that of workers in the industry. This is the sociological aspect. There were no efforts to deal with the problem. There were no claims, just a very superficial investigation. So I got in touch with these people, and I began to develop the groundwork for filing a suit. In this sense, there was a legal process and a sociological process, in that it was necessary to make the law work in practice, since in Argentina there is a disconnect between what the law says and how it works in practice. And since this work cannot be done by one person, it is too much work, we brought together a team of very prestigious lawyers, very capable people with diverse knowledge to draft the complaint. This was a team effort with other lawyers, colleagues. Finally, we signed off on it after 2 years, because when I explained the idea, everyone said it was crazy that we were going to sue the national government, the provincial government, and the municipalities, as well as 44 companies that were among the most powerful in Argentina. Nevertheless, I was able to convince them, and they contributed a tremendous effort. We were able to submit the complaint in July of 2007 to the Supreme Court.
May I ask about money? That's a lot of lawyers, and lawyers aren't cheap. How was it financed? How was the suit financed?
En ese momento,
At this time, the country was beginning to change politically, and new members were appointed to the Supreme Court. With new members that had an open perspective, the court permitted this type of class action to be brought. Since the law provided for it, they recognized that they had to follow the law. Article 41 states that public agencies have an obligation to conserve the environment. It imposes on public authorities the responsibility to go beyond the minimal mandate and commit to caring for the environment, because they are part of the environment and will be affected.
El tema económico es un proceso distinto.
The economic issue is a different process. In environmental cases, in this case, when we started to work on the environmental case with the legal teams in the year 2000, we knew that we would have to invest our own resources to bring these cases, since the victims in environmental cases are the most dispossessed, most marginal, poor people. Thus, we have invested our own money to develop the case. Perhaps, once the case is over and the parties who are responsible for the pollution have a judgment against them, the court will award damages, and we will be able to recover our costs and fees. There is a law that sets the rate for attorney fees in Argentina. So, once the process is over, the national, provincial, and 14 municipal governments already have a judgment against them, going back to 2008. But when the court reaches a final ruling on the 44 companies, if they are found liable, they will pay the attorney fees. For the moment, we lawyers have invested our own resources. I'll conclude. The lawyers defending the companies are legal corporations. They are very big firms. They have received their fees from the defendant polluters at international rates, and it's estimated that they have billed around $400,000 from each defendant company over the course of these years. We haven't billed anything. We have only put in our own money. This is the challenge for environmental cases. The fact that the people affected do not have resources, and to go up against a powerful company or the government, and the time required to go through the entire process to the end, makes it very prejudicial towards such plaintiffs. Even if they get a favorable ruling and remedy at the end of the process, because a lot of time has passed since we initiated the case in 2004. Now it is 2014, 10 years, and we are really in the beginning of the case. Despite the fact that the case itself has been seen as a fantastic thing, and we have made progress in the adoption of environmental rights, we are only just beginning. We haven't won anything. The victims still need to survive while waiting for a judicial remedy. None of the victims have received anything yet.
So the system is still kind of tilted, right?
Sí, hay dos realidades.
Yes, there are two realities. Even though within the judiciary, and the Supreme Court in particular, there are very worthy people who know the law well, it does not acknowledge these realities. There are two realities. One is what is said, and the other is what is done. Today, there may be 200 years of pollution, but in 10 years, they could have done a lot more than what they have accomplished. The court does not have the components, neither the human nor the economic resources, to manage the problem. The government can be ordered to put together a plan to clean up the pollution, but the administration may not have the capacity to follow the order. It is moving along in an improvised manner. In addition to the pollution, execution of the court's order to the administration is undermined by corruption.
It sounds as though, I understand that the court did some very unusual things. It held hearings for many people to participate in. It wasn't just a narrow legal proceeding, and then it afterwards imposed some requirements that other people had to take care of.
Sí, lo importante del fallo.
I believe that the important thing about the court's judgment was the incorporation of a more transparent process. How they handled the cases. In public hearings, they asked each of the 44 defendant companies to respond to the complaints and present environmental studies, giving them the right to be heard and offer explanations. And of course, every one of them stated that they had never polluted. Subsequently, the court did not make them responsible for providing environmental remediation or cleanup of the river and its natural resources. As I noted earlier, this is the government's responsibility. But there was not a lot of confidence that the public agencies had the capacity to carry out the cleanup. So they made a plan called the Comprehensive Plan for Environmental Remediation. And they established benchmarks to monitor the progress of fulfilling the requirements of the plan. The court even imposed fines on public officials who failed to carry out the plan's mandate and missed the required benchmarks. As it turned out, the targets were not met. The supervising judge in charge of monitoring the implementation of the plan has been charged with corruption, along with public officials and the companies handling the cleanup, and the NGOs that also participated in the citizen cleanup. This was another of the court's objectives, to involve non-governmental groups in monitoring the remediation process, were not heard. There were a number of groups involved, like Greenpeace, the Neighborhood Association of La Boca, the Center for Rural and Social Studies. Significantly, human rights and environmental organizations did monitor the process, but their reports and conclusions were not taken into account.
Everybody is I think, impressed with the ideas and with the plan, and they have varying different opinions about how well it's gone.
Yes, this is the contradiction between what is said and what is done. For example, the General Environmental Law has a provision covering whoever is responsible for pollution. Specifically, causing environmental damages, which are understood as relevant disturbances to any aspects of the environment. Natural resources, ecosystems, environmental values, and products. The law requires, and the Constitution does as well, that the first obligation of the polluter is repairing the damage. And the companies in this case and the government are responsible for their actions and omissions. The government is liable for omission, allowing the companies to pollute and failing to exercise proper monitoring. And the companies are responsible as the direct agents of polluting the river. This liability is presumed to be objective according to the law. They are jointly liable, those who act by omission and those who directly pollute. Even if it can't be determined which of the companies are most responsible, they are all held liable. Up until now, all the court has done, after 10 years of litigation, is to enter judgment against the government for its failure to monitor the companies. The companies, despite the suit's allegations, have never been judged liable.
No se ha pronunciado respecto de las mismas, de la responsabilidad de las empresas, siendo que son los contaminantes.
80% of the contamination in the Matanza-River basin, which is the extension of the Riachuelo in its last leg, is the result of liquid waste from 30 companies. 30 companies that have nonetheless yet to be found liable, which, after 10 years, is incomprehensible to us.
Going back to the original case, there were two parts. There was the environmental and there was the health case. And the health one was taken elsewhere? What happened to that?
Correcto.
That's correct. When the court took the case, it divided the allegations of the victims, the affected plaintiffs, into two parts. One part involved individual damages, the specific health effects suffered by individual victims. This other part was sent to lower courts to adjudicate each individual case separately, since the health impacts were different for the individual plaintiffs. The court agreed to hear the part that related to collective rights that are guaranteed by the Constitution. The Supreme Court has jurisdiction over what in Argentina are called collective rights. And the collective, or class action, was severed from the individual health claims. In our opinion, this decision was incorrect. Although there is the argument that the court would be burdened with too many trials at the level of the first instance if it agreed to hear those cases individually. However, in this case, it would have been correct to try all the cases together, because there is a procedure that would allow for anticipation of damages, especially in an environmental case, thus providing the victims with some anticipatory relief, awards for treatment, hospitals, and other assistance, which, with the passage of 10 years, have not been met. Health cannot wait for this period of time.
La salud específicamente no puede esperar ese tiempo.
Is that case finished now, or is that still going on?
We are not even halfway there. We have done a lot, but there is a lot more to be done. Now, after 10 years, we are bogged down with our own life vest.
Has it made a difference in the lives of his clients? What has it done to his clients?
No, this division that was made between collective damages and individual damages made the victim's situation worse. They are hurt since the collective environmental case is under the Supreme Court's jurisdiction, and the lower courts that are adjudicating the individual claims have no knowledge of environmental law, which is underlying the individual claims. The lower courts are afraid of taking on this large case because they are accustomed to handling the classical work of common disputes, like commercial law, and the simple disputes that emerge from daily life. Environmental law is uncomfortable for them to take on because it is not like traditional law. It is a new vision of law that modifies and decodes all traditional legal reasoning. Since the environment does not adjust to law, it has its own law. So, procedurally, it is hard for the lawyers and judges who are involved in the case. They didn't study the subject, nor did I. When I became a lawyer 30 years ago, it did not exist. It has only emerged in the last 20 years or so, since 1994, as a subject to study and an idea to consider. We have a philosophical view. We have had 2,000 years of culture in which humans are the owners of nature, and the laws were established in the function of natural resources existing for the use and enjoyment of human beings, of the human species. By placing humans at the center, law adhered to this cultural concept. Now we are beginning to think that nature, animals, other peoples have rights, and we are beginning to recognize this change in perspective, especially in the countries of South America.
Does the law include natural right or legal rights for natural objects, right? For animals, for trees, for rivers, right?
Not exactly, but yes, they are recognized as subjects of rights, including the generation of cultures, something which had not existed. Implicitly, it does not say so specifically, but it is recognized in practice, since any inhabitant has the third-party right to bring an action against an attack on nature, natural resources, or ecology. Seen from the more human perspective, something I find remarkable is that the Matanza-Riachuelo River seems like it always has been there, and it always has been this way. Yet, it is not a river, since there is no water, fish, or animals.
Es decir, es una cloaca a cielo abierto. Sin embargo,
just an
no hay
open
una sola
cesspool.
manifestación
Nevertheless,
de gente
there has
que
not
vive
been
allí porque ya
a
considera
single
como un
demonstration
estado de
of
cosas
people
que eso
who
siempre
live
fue
there
así,
and see
que
this
se
state of
levante
affairs
a
that have always
pedir
been
por
this
esa.
way, who
Ahora
rise
sí
up and
es
seek
esta causa a
change.
través de la cual se
So this has been
pretende
a big
ese
advance.
avance, ¿no? Antes de la
Before the court's ruling in
creación de
this
la TUMAR,
case,
por
there were
consecuencia de la
39
Corte, de la sentencia de
agencies
la Corte,
that had
había
some
39
responsibility for
organismos
water issues
que tenían incumbencia en temas relacionados con el agua.
for at
Desde
least
hace
the last
50,
50
100
years.
años atrás.
None of
Ninguno
them
se peleaba
fought to
por-
improve it. They
por el
just
río y por
defended
mejorarlo.
their own
Es decir,
interests.
cada uno defendía sus intereses.
It's always been
Siempre
this
fue
way.
así y
It was very well
pareciera
established.
como algo
It's
establecido que
remarkable.
fuera así.
Let me come back to the clients. So the clients, in terms of the health issue, are just hanging for 10 years, huh?
Cada uno se ha arreglado
Each
como
one has
pudo
done
en
what they can in
tratamientos,
terms of
no
treatment.
ha sido reconocido.
They have not been
Y
recognized.
volviendo al tema
And
específico,
returning to
es
this
que
issue,
al haber
because the
demandado
complaints
la
for
causa
health
a los
damages
tribunales inferiores,
were sent to the lower courts, the
los
victims
habitantes de Avellaneda,
face
por
logistical
cuestiones
hurdles
técnicas procesales,
due to
tienen
technical
jurisdicciones distintas,
procedural
tienen un estado
issues
distinto. Entonces,
relating to
cada uno tiene que
jurisdiction.
iniciar un juicio personal
Each victim
contra
has to file
cada una
separate
de las
claims
empresas en las distintas
against
jurisdicciones.
all the companies
Entonces,
in different
tendría que
jurisdictions.
iniciar en la provincia de Buenos Aires.
So people who live
Viven
on the
en
other
el
side of
otro
the
lado del
river
río,
have
de
to
ese lado
file
del río, en el
claims
gobierno, en
in
distintos
Buenos
tribunales.
Aires
Y al ser
province,
tribunales
and those on
inferiores
this side
y,
of the river
eh,
have to sue in different
personas distintas,
courts.
los jueces, pueden haber sentencias
Since they are lower
encontradas.
courts
Uno puede decir
and every case
que
is handled
corresponde,
by a
el otro que
different
no
judge,
corresponde.
the
Por
outcomes
eso
may not be
decía hoy
consistent.
respecto de que fue equivocada
This
la
is why I said
la
that in
decisión
this
de la
case,
Corte en
the
separar,
Supreme
en
Court
este caso
erred
específicamente,
in
los daños,
separating the
porque es
individual
prácticamente
health claims
imposible
from the collective
que
action.
un juez inferior a la
It is
Corte se
practically
pronuncie
impossible
sin
for the
esperar
lower courts
la
to make
condena de
any
la
decisions
Corte a
until the
las
Supreme
empresas
Court
o a los
rules on the
contaminantes,
liability
a
of
los
the
responsables
companies.
de la contaminación.
It's striking that in the environmental case, the court has basically said the basin is one thing. But in these cases, the basin is not one thing, and the plaintiffs have no. Yeah.
El concepto está en la práctica.
The concept and practice are different.
Por
example,
iba a decir hoy, justamente,
This
esta
court,
misma Corte
which favored the adoption
que
of
se
environmental
pronuncia
rights
en relación
and rights for nature,
la incorporación del derecho ambiental y de los derechos de la naturaleza en la práctica a través de
in
hacer lugar
practice,
a
by
esta-
taking
este
this
caso,
case,
es
is
la
the
misma
same
Corte que
court
el año
that last
pasado
year
recientemente cambia
changed
una jurisprudencia
long-standing
sentada
precedent
durante muchos
in
años
its Chevron decision.
en sentido contrario respecto de Chevron. Chevron Ecuador logra una sentencia magnífica en relación a la contaminación
Chevron
de la
Ecuador
empresa
was a
Chevron.
magnificent judgment
Entraba en
in
embargo
that
del embargo
it
a las cuentas
succeeded
a Chevron,
in
a
attaching
Argentina
assets
y
in
en otras partes del
Argentina
mundo para
and in other
resarcirse,
parts of the
y
world
la
to pay for the
misma Corte,
remediation.
con ese principio, esos
But this
principios,
same
reconocimiento de esos
court
principios,
vacated
la
the
excluye a
attachment.
Chevron,
It
cambió la
completely
modificó
changed
totalmente
its
su
own
jurisprudencia
posture,
y le hace lugar
overturning the decisions in the trial court
opinión
and the
contraria a un
appellate
juez de
court
primera instancia,
that upheld the
a la
precedent
Cámara de
attaching
Apelaciones
Chevron's
que habían
assets.
sostenido la procedencia
In essence,
del
in
embargo a
9
la empresa
days,
Chevron.
the court
Finalmente,
erased
la
its
Corte
own jurisprudence, which it had been
9 días
developing over
borró
years.
esa doctrina que había sentado durante años. Esas son las contradicciones
These are the
que
contradictions that
persisten,
persist.
bueno, en las cuales uno tiene que insistir.
One last thing is, you are actually making law. You and your colleagues have been making law, which is quite a wonderful thing. Right?
Sí, y seguimos iniciando nuevas, en mi caso particular, por
Continue to initiate
impulso
rule development.
propio de,
In my own case,
Una vez-
I am motivated.
digo yo, quienes tenemos transitamos por los ámbitos
Once we have gone
académicos
through the
y
academic
tenemos
review,
conocimiento y las
and
herramientas
we
para
have the
hacerlo,
knowledge
frente a una
and
realidad
tools
como
to
puede
act
ser
in
la
the face of
Riachuelo,
reality,
puede ser la
like the
de la
Riachuelo
siembra de
case,
transgénicos,
transgenic
el
crops,
fracking, que es la
and
próxima
fracking.
demanda en la cual estoy
Hydraulic
trabajando
fracturing is the case I'm working on
en
now.
Argentina a través de Chevron.
We have it in Argentina with Chevron.
Una vez que se conoce esa realidad y está allí, se levanta como un monumento.
Once you know the
fenomenal,
reality,
64 kilómetros de
and
río
there is a
contaminado,
phenomenal monument built
no se puede no
64
hacerlo.
kilometers
Es
from the
decir, hay un
polluted river.
compromiso
You can't not
ético,
do something.
natural, si se quiere,
There is an
de que
ethical,
uno
natural
algo tiene que hacer.
obligation,
Lo
if
que
you
no podemos hacer
like,
es
that you
quedarnos de brazos
must
cruzados
take
e
action.
indiferente, pues sería mirar una
What we
sociedad
cannot do
indiferente y
is keep our
loca
arms
que se
crossed
autodestruye
and be
y
indifferent.
permanecer de brazos cruzados, ¿no? Esa es la idea.
6 years after the Supreme Court's landmark decision, the Riachuelo is far from clean, but it's a long way from what it was. Landfills have been cleaned up, most of the junk is out of the river, 200 families have been moved into new social housing, and where their shanties once stood, a linear riverbank park planted with native trees is giving the river back to the city and its citizens. There's a lot left to do, and some tough questions remain unanswered. For example, the disposal of the toxic sediments at the river bottom. This is still a dirty urban river, but it gets a little cleaner every day. And as an example of what can be done, it has shifted the thinking of communities across this country and around the world. But this couldn't have happened in Canada or the United States, because Argentina's legal system recognizes that its citizens have a right to a healthy environment, and North American legal systems don't. For the Green Rights Project and the Green Interview, I'm Silver Donald Campbell.